Distinguished guests and friends, it's a real pleasure to welcome you to this special lecture cycle which is organized by the ICTY and the Grotius Center. We are both very pleased and humbled to host a series of events here at our premises of Leiden University in The Hague. This is a truly historic moment. The tribunal will close at the end of the year, less than 100 days to go. Difficult to imagine. The ICTY has been a pioneering institution. Many of its officials and staff members have shaped the foundations of international criminal justice, and its legacy is a living one. Legacy is, of course, a process. It continues to be shaped in judgments, in narratives, in discourses, not only across countries, but also across continents and fields. And the ICTY will live on in a different capacity. It will retain an important space in international criminal justice. Some might say, ICTY is dead, long live ICTY. The ICTY counts among the most successful experiments in international criminal justice. It was established in the 1990s, and to many of us today, this seems like a golden era or a heroic age of international justice. But hardly anyone remembers how difficult it was actually at the start. Many of the first footprints were shaped by Professor Sheriff Bassioni, who sadly passed away a few days ago. He went the extra mile to make the Commission of Experts work, which turned a success at a time when not all states were enthusiastic about the option of criminal prosecution. Without his contribution, the tribunal might not have gotten off the ground as it did. And maybe the series is also partly a tribute to him. Like other criminal institutions, the ICTY went through different phases in its history. It had first certain teething problems. It was relatively small cases that broke the ice. Don't forget, it was Tadić, the first case. Tadić is now a classic in many criminal textbooks and is perhaps even more famous than other cases against high-level political leaders. Then the ICTY faced a big fish versus small fish question. Did it have enough teeth to go after the most responsible? It ran certain mega trials, like the trial against Milosevic, that showed the complexity of cases, but also some of the problems relating to extensive charging. Later on, the tribunal almost became a victim of its success because it had such a large caseload. This led to high expectations by affected communities, but it also posed certain capacity constraints, and states already became also interested in downsizing. The tribunal solved this partly through the completion strategy. And this completion strategy had positive spin-offs. For instance, a better relationship, increased engagement with domestic jurisdictions. The Rules of the Road program, outreach activities, and referral of cases back to the domestic actually brought the tribunal closer from The Hague to the region. This created a novel platform for dialogue. Now we are in the final phase, legacy, and this is an even broader dialogue that will continue, of course, over the next decades. The tribunal will live on in many ways, not only in history books and memories, but through its working processes, its experiences, its lessons learned, and the voices that it has shaped. The purpose of the coming lectures is to start a discussion. It is structured around different stories. The story of the registry, which might be different stories that we will hear today, stories of the OTP, the defense, and stories of chambers. Many exciting speakers will join us in the next weeks. Each of these institutional dimensions is a small micro-universe. Some of their experiences might be untold. And the purpose of this series is not to necessarily embellish performance, but to share these experiences and also to engage maybe with some of the critiques and lessons learned. Ultimately, it's of course for others to draw conclusion on legacy. With this, it's a great pleasure to give the floor to Deputy Registrar Kate Mackintosh. She will open the series and chair today's first session. Kate is the first female Deputy Registrar in the history of the ICTY. She started her career at the Tribunal with the late Judge Antonio Cassese and also worked at the ICTR and at the ICE. Kate, it's a tremendous pleasure to welcome you here. The floor is yours.
Thank you, Carsten. So I'm the first of your exciting speakers, something to live up to. So welcome everybody to this first in the ICTY lecture series, the story of the registry. I think one of the purposes of tonight, or one of the things we'll be doing through telling this story, is to look at actually what is the registry of an international criminal court. But first of all, before I go there, perhaps we could just say that it's basically everything that's needed to support the core work of the institution, in other words, the criminal trials. It's hard to imagine sitting here in the international city of peace and justice, home not only to the ICTY, but of course to the International Criminal Court, the Special Tribunal for Lebanon, the Kosovo Specialist Chambers. Hard to imagine quite what a new and novel and revolutionary thing the ICTY was when it was created by the Security Council in its resolution back in 1993. But it was really a revolutionary institution. The only previous international criminal courts, of course, were the courts created after the World War II, as you well know, in Nuremberg and at Tokyo. And from a registry perspective, in terms of what was needed to support those trials, the environment was quite different. Those trials were supported effectively by the occupying powers in Germany and Japan, who provided a context for the trials to take place. Now, when the Security Council created the ICTY in 1993 and decided in the statute of the tribunal that it would be headquartered in The Hague, clearly it was quite a different situation. The Security Council was not occupying the Netherlands, and the International Criminal Court the International Criminal Tribunal for the former Yugoslavia had to work out for itself how to build this structure. And that's essentially the story of the registry. And tonight we're going to be looking at what that's ended up being, what the registry of an international court really has become. And for us at the ICTY, because we were the first international criminal tribunal in this period, there was really no blueprint. And we'll hear actually from the next speaker, who was here right at the beginning, perhaps a little more about what it was like at the beginning. So the tribunal had to work out for itself basically how to run something as complex as an international criminal trial. And I'll talk more and we'll hear more about what that complexity consisted of. But it included arresting and detaining accused. It includes assigning, paying for defense counsel. It includes bringing witnesses. It includes protecting those witnesses. It's a vast range of activities. So, what does it look like? I will try and give you an idea. I'll try and map out the range of functions that the registry covers, and then we'll take a deep dive into a couple of different issues with the excellent panel of speakers we've got here tonight, who I'll introduce later when they go into their specific areas, but you can see on the invitation their job titles at least. So why is the registry of an international criminal court such a strange or unique institution? Well, I like to explain it by looking at it in three different areas of support it has to offer. So first of all, we have the registry offers the same support that would be offered to any international organisation. So any other international organisation around the world will have support functions such as, of course, finance, budget, security, building management, everything that we refer to as our administration. And we have our chief administration here. And also sections that will deal with external relations, of course, and diplomatic relations as an international organisation. So we have that in the registry, which is something that would be found also in other international organisations around the world. We also have support functions that are specific to a court or a criminal court. And there, largely, I'm talking about court operations, so running the actual activities of a courtroom, and also judicial records, maintain the judicial records. So that, I think, was what would normally be referred to as a registry, just that part, in a national court system. Of course, we do that as well. And then we have this range of functions that are really specific to an international criminal court, to the support of an international criminal court. So we have some functions that are related to the fact that this court was set up, of course, outside the country where the crimes were committed. So we have, for example, to bring witnesses to the court. Most of the witnesses who've testified at the ICTY are located in the former Yugoslavia, where the crimes were committed, clearly. So these people have to they have to travel to The Hague, and we realized that it was not going to be enough just to allow these witnesses to be summoned. Some of these people had never traveled to the capital city in their own country, let alone been on an aeroplane or come to The Hague. So we've developed in our witness support section a function whereby certain witnesses are actually accompanied by one of our staff who travels to their home in their village and travels with them to The Hague. They have to be housed in The Hague and looked after for the length of their testimony. They need a whole range of support to understand what they're going to go through, and they may need other kinds of support. We have a whole system set up whereby we can, for example, help them with childcare or loss of earnings and so on when they come. So that's something really specific, I think, to an international criminal court. We also have an enormous section dealing with translation and interpretation, and we have here Maja Ružić, who's the chief of our language services section, who'll be talking about some of her experiences later. But of course, the proceedings take place in English and French. Those are our two working languages. The crimes took place in a completely different language. The crimes took place in, what used to be called Serbo-Croat, and as I think we'll hear from Maja later, we've made a new language out of that called BCS, but I'll leave that to Maja to explain. So we have a huge section about that. And then the other function which we've developed, which is very significant, and Carsten alluded to it already, that is related to the fact that we're outside the country where the crimes were committed, is our outreach work. So we have a team of staff, both here and in the countries of the former Yugoslavia, many of them sitting here with us tonight, who are really dedicated to bringing what's happening in the courtrooms in The Hague to the affected populations in the former Yugoslavia. And that's been a really significant and crucial part of our work. And as you will all know, I'm sure, successive international tribunals that have been set up have all adopted this outreach function as part of their work, because it became clear through the ICTY experience that if an international criminal tribunal is to have any hope of achieving any of its goals in terms of having an impact on deterrence or reconciliation or any of those higher goals that we might aspire to from this kind of post-conflict justice mechanism, it will have to put serious resources into bringing these criminal proceedings back to the people affected by the crimes. The other area of registry functions that are related to it being an international criminal tribunal in particular devolve from the fact that we operate outside a state. So I referred to the way that the Nuremberg and Tokyo trials were able to draw on the resources of the occupying powers in Germany and Japan. And I made a joke about the fact that there's no occupation here, but we're our own international organisation. We're supported, of course, by the United Nations, but we don't sit within the administration or the judicial administration of any state. So functions which would normally, in a normal criminal procedure, would be taken on by the state, the registry has had to create. And I'm thinking here about, for example, detention, and we've got the commanding officer of our detention unit here to talk about some of the challenges in detention in a bit more detail. Now, we work with of course, with the host state, with the Dutch authorities who provide us with the actual physical prison, but we're responsible for the detainees. So the ICTY, the ICTY, the registrar in the first place, and ultimately the president, is responsible for the welfare of all of our detainees. So we have drafted our own rules of detention, approved by the judges, and a whole series of regulations underneath that, and we administer the detention system ourselves. That's a very important part of registry work. I referred to the witness support. We also have the issue of witness protection. Normally, of course, that would be dealt with by police forces in a particular state. And again, we collaborate with police forces in the relevant state where witnesses are located. But we have our own, we've developed our own witness protection function. We retain responsibility for the protection of witnesses who've testified at the tribunal. Another area is in the area of defence. Our accused, of course, have a right to defence counsel, which most of them exercise, not all of them. And we'll hear from Ljiljana Hellman about the pro se accused who decided to represent themselves and what we were then obliged to put together to support that. But most of our accused opt for defence counsel to represent them. There was no international bar that we could look to regulate the conduct of counsel. We had many of our accused are indigent. They can't actually pay for their own defence counsel, so we had to establish our own payment schemes. What we actually did, one of the main ways that we've gone forward there is through collaboration with an independent body, which we fostered the creation of, the Association of Defence Counsel at the ICTY, now the Association of Defence Counsel at International Criminal Courts, I believe. So we created effectively, or we encouraged the creation of an independent body who would function at like a national bar might do in a normal national jurisdiction. So this would be a body with which we consult on rule changes, we consult on payment schemes, they can represent the defence. And then we in the registry administer the payment of the defence. So we've essentially created our own legal aid scheme and administer it as well. I think that gives you a bit of a view of what the registry looks like. As I said, it's quite a complex and multifaceted organ. I'm assuming that the majority of people here today are law students or working in the area of international law. So I thought before I hand over to our speakers, I might just give you an idea of what the legal work consists of in the registry. Now, I have to confess, I started in the International Tribunal, as Carsten mentioned, I started working with Judge Cassese as his legal assistant, so working on the actual cases. And I remember thinking, are there lawyers in the registry? What do they do? So you may think that too. So I thought I'd take the opportunity to give you an idea. So as lawyers in the registry, what do we do? I'm a lawyer. The registrar is a lawyer. It's a requirement at the ICTY for those positions to be lawyers. It's actually not a requirement, interestingly, at all of the international criminal courts, I notice. It's not a requirement at the International Criminal Court, in fact. But what do we do in the registry, legally speaking? Well, we file multiple legal submissions on issues arising in the cases. So in a busy period, we would be filing multiple submissions during the day on matters falling within the jurisdiction of the registry. So the whole range of issues that I've just outlined for you there. We can make submissions on any matter in the context of a specific case, and that's actually set out in Rule 33 of our Rules of Procedure and Evidence. We work on developing and interpreting the legal framework generally. So the registrar or the registry, we can propose amendments to the rules of procedure and evidence. In fact, we are required to, or we are looked to propose amendments in areas of our responsibility. We draft the rules of detention, which are amended and adopted by the judges. We've actually just been through a major project to draft the rules of detention for the successor institution to the ICTY and the ICTR, the Mechanism for International Criminal Tribunals. And we draft and interpret the lower level documents. Notable areas include detention. You'll hear, again, as I said, from Fraser about this, that we have a range, of course, of regulations. So that requires, those, of course, have to be drafted and interpreted coherent with international human rights law. We also have other areas of support to prosecution and defence teams, where we draft and interpret regulations, and that, of course, requires coherence with the right to a fair trial and equality of arms. We draft and advise commercial contracts, that would be like any international organisation, as well as MOUs with states and international and non-international organisations. We deal with questions of privileges and immunities under the UN Convention on Privileges and Immunities. And with regard to that, and also the drafting of MOUs, we collaborate closely with our colleagues in New York at the Office of Legal Affairs. We deal with staff litigation. The United Nations has an internal justice system, which was introduced not that long ago. It used to be impossible to sue the United Nations. Now it is possible to sue them if you're a staff member. So any administrative decision taken by the registrar, the registrar is the administrative head of the institution, so taken by the registrar or the deputy, can be challenged in the UN justice system. So we deal with any of those cases. And finally, and I think maybe most interestingly, we've developed at the ICTY a system of internal judicial review, and I mean apart from the staff administration issues, essentially to two categories of people who are not staff, and that is the detainees and defence counsel. So we have a system whereby the president of the tribunal reviews decisions of the registrar according to principles of administrative decision-making, so it's a standard judicial review, for those of you familiar with that, with regard to detention and also with regard to legal aid. And I just leave you with the thought, I think that's particularly interesting because I do think it's really unique in the UN system that decisions that are made affecting non-staff members have some system of recourse. So, of course, there's lots of discussion about beneficiaries of UN programs in the field, for example, and a lack of accountability. And I'd just say that we're an institution which actually does have accountability for decisions made that affect people who are not staff members. I personally think that's an interesting point. Anyway, on that point, I think I will hand over to the first person who's going to give you a bit of a deep dive into one particular area of the registry work, and that's Mr. David Falces. David is our Chief Administrative Officer, so he's the head of all the administration at the ICTY. David is also the ICTY's longest-serving staff member, having started on the 1st of March 1994. So I think David is going to maybe take a little dive back into the early days and give you a bit of an idea about his experience and what the registry does in his area of expertise. So thank you very much.
Thank you, Kate, and thank you for not calling me the oldest serving staff member of the tribunal. In fact, you mentioned that I started in March. I actually started in January of 1994, but it was one of those administrative contractual issues. I don't think they really considered me a staff member back then. But in any event, so I've got a complete inventory of all the administrative services, and it should just be a quick 100 slides that I'm going to go through. Kidding. Whew. Sigh of relief. I'm going to take maybe a more anecdotal approach to the description of the way administrative services work in the international criminal environment. So essentially, maybe I'd just like to say thanks to Carson and to Kate for opening us up, and maybe most of all to our brilliant colleagues from Communications and Outreach who've done a fantastic job in arranging this and getting us all here and you here as well. So thanks to you all very much. A little bit about myself as a sort of a way into administrative matters. I'm originally from San Francisco, California, and in 1989, I joined the United Nations in peacekeeping, and I spent 5 years basically doing things like running around in Namibia and Angola. I was in Somalia, Lebanon, I was in Syria, and the former Yugoslavia. And I did things like hook up computers and install administrative systems, and I was the IT guy basically running around, and it was a lot of fun. We did elections, we did famine relief, we did disarmament, we did cantonment of forces, truce supervision, all kinds of fun things in peacekeeping. And for me, it was fantastic. I really was in love with this line of work. I felt like sort of the Indiana Jones of IT. So I don't think I ever would have left that, actually. But at the time, my girlfriend said, well, this is all very nice for you, Dr. Jones. But we never actually get a chance to see each other. And she was living in New York at the time, and I was like semi-based out of New York, but sort of traveling up, down, right, left, and center. And I said, you have got a very good point there. And I'm sort of thinking, maybe I'll sort of throw a little bone and take a short-term assignment somewhere nice and sort of stable, like The Hague. So I think it was December of 1993, just managed to find this posting in The Hague, and because I'd actually also been in the former Yugoslavia, I had seen the destruction and the misery of that was caused by the war. And so it actually, in addition to being sort of a nice personal break for me, it was like I had a connection to it as well. So it was one of those things where I just said, fine, I'll give it a shot. But I think everybody at the time thought that this experiment in international justice was never going to last long, and it was just sort of a short-lived thing. And all my colleagues were saying, great, you'll go there for a couple of months, and then you'll be back because the whole thing will close down. And we heard that actually quite a lot in the beginning. So actually, I got here in January 1994, and my initial reaction was, why is the rain coming in sideways in this place? I think I'd come from Lebanon just before that, and so there was like this shock of the weather. And I thought, they were right, I'm not going to last more than a few weeks here, but here I am 24 years later, and impervious to the rain, I think. And it was a sudden deceleration from my life in New York and in peacekeeping, because Albert Heijn closed at, I think, 5 o'clock at those days. And so for anyone who was like working normal sort of startup hours until 11 o'clock at night, it was like, I think I ate a lot of dinners at the Shell station at the Burger King at the time in Scheveningen, where I was living. But the work was incredibly energizing and engrossing, and we were surrounded by a fantastic group of colleagues who, just by their very presence, were very enthusiastic and very inspirational. So I think essentially in those early days, there was a lot of people sort of built on each other, and I think it was very clear to my memory that it didn't matter if you were in the chambers, if you were in the registry, you're in the prosecution office, everybody was sort of working together, and it was, all hands on deck, and sort of like a, I don't know, Mickey Rooney and Judy Garland show where it says, okay, let's get this show together. So fantastic working with all those very sort of innovative and results-oriented and creative people, I think, and hardworking. Now, a little bit about the work that we had to do, and you mentioned Sharif Bassiouni, actually, in your opening remarks, Karsten. I had the privilege of actually working with him in the very, very first days. He was working with the Commission of Experts, and the Commission of Experts actually had gathered about 70,000 pages of evidence from their work in the former Yugoslavia prior to the inception of the ICTY. I think probably they were the genesis of the resolutions which led to the creation of the ICTY. So they had this fairly large collection of evidence, which of course now is in the millions of pages. And they were the first few pages we had. And his team had actually taken those and they put them into a database and digested all the evidence about who the perpetrators were, who the witnesses were. And they had got it all in this massive database. And so actually went to Professor Bassiouni's operation in Chicago at the time, and they handed over the database, which actually it was a dozen floppy disks. So I'm dating myself there, I know. And I took those and I brought them back to The Hague and I gave them to the prosecutor, and we were off. Work also included conceptualization and building of a fully technologically integrated courtroom with full television production facilities. And we're lucky to have actually Rob Barsoni with us today. He's sort of in his role as cameraman today, but he actually runs the outfit now. At the time, a courtroom like that actually didn't really exist. There were a couple of sort of proof of concept models that were around in various places. The column of William and Mary in the States. But this was something which was a fully functional, actually meant for actual proceedings courtroom, which really did feature sort of live broadcast TV at the time. And just to put it in perspective, the other trial, which was receiving sort of a lot of coverage in terms of live TV broadcast, was the O.J. Simpson trial. So we were reacting at the time to, okay, how are you going to present this trial? How is that going to work technically? If you remember the O.J. Simpson trial, I'm looking around the room, maybe some people do, some people don't. There was a lot of sensationalism where people were zooming in on witnesses crying, and we actually worked together with all the parties. And I think this is a hallmark, essentially, of all of our work in the administration, is that we worked really cooperatively, and it's really active partners with substantive offices to come up with solutions and get results. So we worked with the judges, we worked with the legal teams from both the defense and the prosecution, we worked with the registry, We had our security operation there, which had to be engaged, and of course we worked with the movement of the detainees, and so all these elements actually sort of have to be orchestrated and come to a sort of a point when you actually get into trial, which is it's the function of the tribunal, essentially. So we actually made that happen, and that was a tremendous accomplishment for us, and we actually now see echoes of that in all of the other sort of international courts nowadays, which, of course, there have been incremental improvements here and there, but essentially, most of these courts are essentially building on that early model that we had with complete technological integration, evidence appearing on screens, broadcast of the proceedings, live transcripts, witness protection measures, technological witness protection measures, so on and so forth. We also set up the first remote witness testimony via video teleconference. And I remember actually traveling down to Banja Luka, where we actually set up an operation in sort of an old motel that the UN had sort of taken over there. And it was the first one we've done of its kind, and we actually had the witnesses, of course, were there, but their counsel, and we had the registry officers there. We had security running, because actually it was still during the course of the war. And there was full interpretation happening, and we had live transcript and use of exhibits, paper exhibits, which is actually being presented to the court remotely via this video teleconference. So fantastic technical challenge, and I was the IT guy, right? So it really had me very happy doing that kind of work. All kinds of things that we did. We worked with the OTP in terms of sort of gathering evidence from the former Yugoslavia, bringing it back, scanning it, classifying it. The sorts of really sort of massive operations that were incredibly challenging. And again, I think the hallmark of working sort of as an administrative unit in the ICTY was that we were always working in close cooperation and coordination with substantive offices. So it wasn't like we were sort of the paper pushers who were, the bean counters who were, sort of following after the fact. We were tightly integrated in operations, and a very satisfying and fulfilling way to work. So at a certain stage, I think, and probably because of the unique insight that I was given in getting to see all these various aspects of the operation, they kicked me out of IT, and I went into general administration. And from there, I think, we just went on to things that, opened my eyes even further, and I think some of my esteemed colleagues will talk about some of those things more and more, but we worked with confidential witness operations. We set up the schemes for how things were handled administratively in the remuneration for defense counsel that Kate was mentioning. Fraser, we remember many months where we spent a lot of time negotiating the commercial contract, or the contract, I should say, for the detention and services facility contract. And all these things were actually done in the context of the United Nations, which is a fairly well-established bureaucracy. And so often working in sort of the framework of sort of set rules, you have your financial rules and regulations, and you have to think sort of how can we make those rules work with the operational demands of the judicial program of the court. And that was always a lot of fun, challenging. And I think especially because there are so many of the aspects of the work of the court which are confidential, challenging these days, because we've just installed an enterprise resource planning system, an ERP system called Maja, which is based on SAP. And that the hallmark of that, of course, is that everything is transparency. Everyone in the UN world can see all the transactions that go into every organization's ledger, essentially. So obviously we couldn't have that. So we actually had to come up with ways by which we could still use the standard accounting systems of the UN, but have our operations remain confidential and secure. So yeah, that's it's still an ongoing challenge, but I think we've succeeded so far. The things that we're working towards, and I'm getting close to the end, don't worry. We're now liquidating. After 23 years of an amazing operation, we're in the stage where we're liquidating. And when I took over this position, I think we had about a little over 1,100 staff at the ICTY, and now we're about down to 160 or so. So you can see there's been a substantial reduction in force of the ICTY staff. And the liquidation, as it's called in the United Nations, actually involves also the liquidation of assets. So we have to write off assets, sell things, transfer them to other organizations. We have to regularize contracts of our commercial and non-commercial partners. One of the big things we have to take care of is the transfer of records and archives. That's an important function that we have. And again, coming back to the staff, essentially, it's a question of a fair and transparent way in which we can release staff. And it's, I'm one of the staff that's being released in the next several months, so I know that it actually is sort of a life-changing experience. I got my termination notice on Monday, so I think I'm just going to sit at home and work on my Xbox skills after that. At the same time, we're liquidating, closing down the ICTY. We've been very busy in setting up the mechanism for international criminal tribunals, which is the successor organization to both the ICTY and sister tribunal, the ICTR, which was established for the Rwanda genocide. And there's been a lot of challenges with that. So at the same time we've been closing one, we're actually building up another, which is full of challenges. For example, we just built a new facility in Arusha, Tanzania. And we're expecting a relatively full judicial calendar and workload for the mechanism. So the work doesn't stop. We're still going. It's under new management. And I think the mechanism, having built on the foundations of both successful organizations before it, as well as a number of probably new innovations, I think they're going to do quite well. Again, I just wanted to underline that it's a unique organization, and I think we've been lucky in the administration to be able to work with those unique circumstances and to be a really integrated and a full partnership involvement with the entire organization. The environment these days is very challenging. I think everyone knows that we're in the midst of still in the midst of a global financial stress. We have a very stringent regulatory framework to work with at the United Nations. The organization itself, being a judicial criminal organization, has quite a number of stringent sort of frameworks that they work with. They have the rights to the accused and the protection of the victims and witnesses. And it's actually something which is difficult on most days, extremely challenging on others, but always in the end very rewarding to come up with a solution to. I had been asked to comment on working with lawyers. I'm not a lawyer. I'm probably one of the few of the organizations who's not a lawyer. And you've all heard the probably a little bit trite saying that working with lawyers is like trying to herd cats. Yeah, I don't think that's really that apt. I think the most difficult part of working with lawyers is getting the cats to sort of fill in the forms and do the mouse clicks. But lately, I've been thinking that the cats have been herding me the entire time. So they're very clever cats. Our next challenge, and I think the challenge for international criminal justice, is actually showing that we provide value for the world and for the member states. And very often I think this falls upon the way that people assess things from an administrative perspective. So you're spending this much money, what are your results? And we at the ICTY have undergone an evaluation recently in this regard. And I think it's become very clear that essentially we're not building widgets. So we're not a factory that has a product per se, and that you can't say money in, widgets out. But on the other hand, that's the sort of framework, that's the mentality that we're looking at in terms of justifying what we do and what we achieve. So we're being asked to show compliance and results and efficiency and effectiveness and economical results, so on and so forth. And I think that's it's natural that our paymasters from the General Assembly and the UN would think this way, because I think a lot of typical UN operations would be amenable to that sort of evaluation and analysis. I think international justice is probably not one of those areas which is immediately that way, and I think we need to really think, and I'm sure everyone here is going to be part of that conversation about how one actually comes to a conclusion about what value we bring to the world. So In closing, maybe I can say before I pass on to my fantastic colleagues I've adored working with, after 24 years, I'm profoundly satisfied with having done the work that I have. And essentially that I think we've achieved an amazing amount, and I am very proud to have been a part of the team that was put together to try and achieve those results. Thank you all.
Thank you, David. I think, it's really special to hear someone like David talk about his work who's really seen the whole life of the tribunal. And I never heard that story before, so that's a big bonus for me. I think you touched on a number of things, David. You gave a really good impression of what it's like trying to take a UN structure and make it fit a criminal court. And I think that's a bit the story that you're going to be hearing tonight, how we have attempted to how the registry, as the support function, has attempted to fit this new animal of an international criminal trial and what we've had to do to come up with it. So thank you very much, David. That was fantastic. What I might do, actually, if you would like, is already take any questions or comments. I'd like this to be a fairly participatory event, and also I think it's quite hard to listen to 5 people or even 6 people talking in a row. So if anybody has any questions now to David or to me about anything we said or anything else, please feel free to ask them. Maybe even thinking about whether you might ask a question will get some adrenaline going and perk you up a bit. Shall I ask? No, it's going to sound stupid. Oh, great, a question.
Yeah, my name is Joyce, and I'm an LLM student here. And you mentioned earlier that that now under the registry there's a mechanism for third-party claims, and I was wondering if, in your opinion, this mechanism could extend in future, for example, to issues that, for example, we see in Haiti, or in that sense.
Yeah, that's what I think is so fascinating about it, is that it's, as I said, I think the only example in the UN where there is some accountability to external parties. I'm obviously in favour of accountability of the UN and of anybody else. So I think it's worth looking at it as a model. Realistically, I have thought about this. Realistically, it's hard to see how exactly that model could be rolled out to any beneficiary or anyone affected by an act of the UN, because it is pretty labour intensive. It's like a judicial review proceeding. So the complainant files, we respond. It's quite heavy. I don't know if it might be possible though to take some inspiration by that for a different kind of complaints mechanism where the procedure might be a little lighter. I think that's worth some creative thinking about it, but that's exactly what I was referring to. That I think it would be nice I think we should publicise a bit this aspect of the work and the way that's happened here, because I think it is a unique example, and perhaps it could feed the thinking of people about wider UN accountability. Yeah.
Thank you.
Thank you very much. My question is for David. My question is for David. Thank you for the wonderful presentation. You said the new challenge in international criminal law is to show value, and you think that it's not actually important in international criminal law to show the value or the product of money or budget of the UN or somebody. But do you think, especially this applies for ad hoc tribunals like the ICTY and the other ad hoc tribunals, they are specifically established to produce or to do something specifically. So do you think we can think of this kind of ad hoc tribunals without expecting this kind of value if the UN or other organs are actually putting money on it?
Thank you. I think there are certain quantitative measures you can look at for the ICTY. We had 161 indictments, and those have all been handled, essentially. So there are things we can say very quantitatively and very objectively that the ICTY has accomplished. what I was referring to is that essentially for the value for money, I always think like an administrator, and people ask me questions as an administrator, for the investment which the international community has made in this court and other courts, have they gotten what they want from it? In other words, there are a lot of things competing for resources these days, and has this been a good investment for the international community? I think probably the answer is not going to be only in terms of these sort of quantitative, objective terms. And this maybe goes more towards the mandate of the ICTY, which is, I think, was established under Chapter 7 of the United Nations Charter. So it's in what sense, as a broader sense of justice, has been brought to the former Yugoslavia and therefore to the world and by our existence and the work that we've accomplished. So I think it's going to be something which is going to take some thinking on the part of people, the member states, people who are working at the courts, the general public, to determine on what basis essentially the results and the work of the tribunals and the courts is judged. And I think, I attended a lecture on the subject at the Hague Institute, I think must have been a year ago or so, and I think it was sort of the collected wisdom of several of the international courts and a lot of the sort of participatory NGOs and a lot of academics on the subject, and I think it was something that was not immediately clear as to how to do that. But work is ongoing. I think essentially what they said was that they were going to continue trying to work on that and establish a much more sort of systematic and disciplined way of determining what those qualitative benefits are for the results of international criminal justice. Sorry, I'm an administrator. I tend to have a tendency to sort of ramble a little bit. Am I hitting the points of, yeah? Okay. Kate, maybe that's something that you can comment on as well.
No, of course, it's a fascinating question. I think, we've also looked at how is judicial efficiency, and there are two different things. I think David's talking about a bigger question, actually. We were confronted with this strange situation where the people that evaluate UN programs came to evaluate us, and it just didn't work. It didn't fit at all. We have, for example, our product, our projects are very, very strictly time regulated, but not by a kind of project logistical framework, or they're regulated by our rules of procedure and evidence with a series of guidelines, deadlines. Any request for an extension of deadlines has to be made to a judge who will examine, who will consider whether it's justified, grant it, not grant it. So, and all of that was quite unknown to the evaluator. And so we had this sort of struggle. It was a classic example of this thing of trying to fit an international criminal court into a UN system. It just didn't work. And they're sort of falling back on, well, how long did the trials last? And we're like, yeah, well, some trials are like one person who's got 5 counts in the indictment, and some trials we've got 6 accused, and it's the first, or the second case looking at the Srebrenica genocide. The fact that one lasts longer than the other. And I think it became very difficult, but I think it was very interesting for us to think about measures of judicial efficiency. And I think it's worth international courts thinking about that, but it's not something that can be imported from UN program evaluation, that's for sure. And I think even in national systems, the work that's been done on judicial efficiency is, it's not necessarily transferable in any simple way to the kind of work that's done at an international criminal tribunal with the complexity and the size of the cases. But personally, I think it's interesting to think about, however.
Hello, just a question. Do you think the difficulties in the investigative phase, due to the nature of the work you're involved in, is contributing to this inability to show value? For example, there would always be witnesses who are, there will always be a difficulty in bringing in witnesses or victims traumatized who would not be ready to speak about their experiences. So to what extent is that sort of hindering you in showing positive value?
I think I'll jump in because I might be giving the wrong impression. We consider that the ICTY has been a massive success. So we had, as David said, we'd had 161 indictments were issued by the prosecutor and confirmed by a judge. Every single indictee has been accounted for. And what that means is either they were transferred to The Hague, where they were tried and either acquitted or convicted. They were either referred to a national jurisdiction, which happened with lower level accused at a certain point as part of our completion strategy, or they were found to have died, essentially. So we had 100% closure and accountability rate, which is unheard of in a national jurisdiction, let alone in an international one. So we haven't actually faced a problem of not being able to progress cases due to witnesses not coming. You know, perhaps remarkably, actually, because your point is a good one. Of course, this is very difficult areas to testify about, and that's one of the things the registry's worked on. The witness support, we developed, for example, we have a whole program of psychosocial care for witnesses who need it. And we also have referral networks for witnesses when they go back to their home country. So we work with the state authorities and NGOs and so on to try and support that. So I think we think it's a massive success and we're really proud of it. So I don't think it's a question of, there's not a problem showing value. It's more this, I think there's this issue of quantifying, efficiency. That's an interesting question. And of course it costs a lot of money. I think not just at the international courts, but if you look at national prosecutions of this kind of crime, like in the Netherlands has been, really outstanding in its commitment to prosecuting these kind of crimes. The cost of even one of those trials in the Netherlands, they tried, investigate one. They do one at a time. They have a whole unit working on them, and each trial lasts for years. So it's an expensive business. So I think David was more referring to the metaphysical question of, for us as people living in this society, are we willing to invest this time and this effort and this expense, which is inevitable if you want to do criminal justice properly, in order to try and deal with these kinds of atrocity crimes? So I don't know if you want to add anything to that, David.
No, I rarely get a chance to be metaphysical, so, I took the opportunity, just jumped on it.
Okay, I think I'm going to move on. Oh, we have a question. Could you save the question? There'll be another opportunity. I want to move on to the next speaker now. So I'd like to introduce Maja Ružić. Now, where is my list of long-standing staff members? Here it is. Maja is our 8th longest-serving staff member. Maja started in 1995. Is that correct? With us. Maja is the chief of our language services section, which is extremely substantial. I think it was our largest section for obvious reasons. And I'm going to hand over to Maja to talk to us a little bit about what that aspect of the registry work means. Maja.
Well, first of all, let me say that I'm real happy to be here and to have an opportunity to say a few words about the language service at the ICTY. I love talking about our service, so if I get carried away, Kate, please just interrupt me. Also, to give you some information about my background, unfortunately, I don't come from San Francisco. I come from the former Yugoslavia, which I left in '91. And in 94 or 95, I was living in Brussels working for the BBC European Radio when I received a call from the ICTY, and I was asked whether I would, by the way, by profession I'm an interpreter and a translator, whether I would like to come over to The Hague, to the Tribunal, for a couple of months. So I thought about it and decided, why not? I came over. And instead of staying 3 months, I stayed, 23 years? 22 years? Yes, 22 years. So here I am. Now, as you all know, there's no international justice without interpretation and translation. So at the Tribunal, as part of the registry, the language service provides interpretation and translation services to all organs of the Tribunal, meaning, well, of course, to the registry, but also to chambers and to the defense. And I think it is a good idea to have a neutral language service that provides services to all organs of the institution. Unfortunately, some of the international courts did not follow our example. Some did, and we'll never know, or maybe we will one day, what was the best solution. Now, as Kate already mentioned, the working languages of the Tribunal are French and English, but we also have, as working languages, the languages of the accused, because of course they have the right to follow the proceedings in a language they understand, and also receive documents in that language. And in most cases, the language of the accused was BCS, as Kate mentioned, which stands for Bosnian, Croatian, and Serbian. But we also had accused whose languages were Albanian and Macedonian, so we also provided interpretation and translation in those languages. Now, the service itself was established in '94. I joined, as Kate mentioned, in '95, beginning of '95. And the language service was a very small unit, pretty much like the rest of the tribunal. And we were back then all multitaskers, doing translation, revision, interpretation, of course, depending on the language combinations and so on. And as David mentioned, the working hours were very flexible. We would often stay very, very late at night, like working till 11 o'clock in the evening was, back in those days, first couple of years, the norm. And it was the enthusiasm of working for a new organization for international justice, and the war was still going on in the former Yugoslavia. So there was the adrenaline, and also sometimes a glass or two would help. Back in those days, you were allowed to drink at work, late in the evening at 11 o'clock. Now, and of course, back then, we never thought that we would end up translating more than 1 million pages in different languages and providing over close to 80,000 interpreter days in this unique judicial setting. And at the height of the ICTY operations, the language service numbered over 150 staff members, so translators, interpreters, and language assistants. Now, the service itself is divided in units. So we have the French translation unit, obviously translates everything into French, the English translation unit, and the BCS translation unit. I'll come back to BCS in a second. And also the interpretation unit and terminology and referencing. Now, as you all know, language has always been a powerful tool, not only in judicial settings, but even in everyday life. We know how language can be used sometimes as a good tool, sometimes as a bad one. But from day one, language was one of the issues at the tribunal, the language or languages of the former Yugoslavia. And that was hotly debated and used, especially in the very beginning, as a political and strategic tool. Now, to give you some background information, before the war, some of you were not even born back then, in the former Yugoslavia, there was one official language called Serbo-Croat, so Serbian and Croatian, and there were other distinct languages, Slovenian, Macedonian, and Albanian, but it was Serbo-Croat as the main official language. Now, as the conflict broke out, and basically it was a conflict between ethnic groups, language all of a sudden became very, very important. And all the parties to the conflict started claiming that their language was completely different from the other languages. And so all of a sudden we had Serbian, we had Croatian, we had Bosnian, not like one language or different variants of a polycentric language, which basically it is, but separate languages, hardly anything in common. Well, no, I'm joking, but basically everyone was insisting on their separate language. And the differences, just to give you an idea, between the variants are sort of like between French and Canadian French, or let's say British English and American English, or Australian. So you can get an idea what I'm talking about. And in some cases, the newly established states went to such extents that even, for example, they would broadcast, let's say, something on television, let's say a Serbian movie, and they would put Croatian subtitles, which was absolutely ridiculous. It's like having, a British movie and American subtitles. But anyhow, that was the atmosphere back then. Although before the war, the people in the former Yugoslavia had no problem, watching television regardless of the variants, or going to the movies, watching, movies in the different variants. But, well, it became an issue. And, of course, at the tribunal, it became an issue as well. And it was actually the defendants, or even better to say their lawyers, who raised the issue of language and started using it as a strategic and political tool, challenging translation and also and mainly interpretation in the court, claiming that their clients cannot follow the proceedings because interpretation is in a language they don't understand, which of course was nonsense. And there was this one occasion, it was, I think that was the second trial, the Celebici trial, where the lawyer interrupted the proceedings to say that his client, that we had to stop because his client could not follow the proceedings because it was in a language he did not understand. And while the lawyer was addressing the judges, very confident, there was his client behind him going like, no, it's okay, I can understand everything. So, okay. Well, at least he was honest about that one. But anyhow, the ICTY had to address this from the legal point of view. So the language services contacted experts, international linguists, so that they would give their expert opinion on the different variants of the language, BCS. So. And of course, their opinion was that basically it was one polycentric language with different variants, and that that speakers of different variants had no problem whatsoever understanding speakers of other variants. And based on the expert opinion, there was a judicial decision issued by the tribunal, and actually. Just to mention what made our life easier and also what facilitated the rendering of this decision was that the drafters of the statute, which is the basic document of the tribunal, were very smart, and they used the word language that the accused understands. They did not use the word mother tongue, and thank God they did it on purpose. So no one could claim, well, that's not my mother tongue because I don't know, I'm a Bosnian Croat and I speak Croatian, although actually they do speak Bosnian, but not Croatian. But somehow language became a synonym for ethnicity. So we had the decision, and that's when we coined actually a new term, abbreviation, BCS, in order to deal with Bosnian, Croatian, and Serbian as one language for interpretation and translation purposes. And of course, that went against the prevailing climate in the region, but it was a very efficient solution which saved a lot of money for the institution because, for example, in the courtroom, instead of having 3 interpreter booths, and let's say there are on average 2 to 3 interpreters for each language, so that's 3 times 3 interpreters, that's 9. But we had 1 BCS booth, and we had interpreters either from Croatia, Serbia, or Bosnia, and you would hear the variants like every 20, 30 minutes because interpreters change. Every 20, 30 minutes you would hear a different variant. And I'm glad to say that other international organizations have followed our example, although for political reasons in some institutions, for example, in the European Parliament, because Croatia was the first of the former republics to join the European Union. In some cases, they still have separate booths. So you have the Serbian booth, you have the Bosnian booth, and you have the Croatian booth basically doing the same job. But, well, that's the way it is now, but they're also heading towards the BCS approach. Now, I would like just to say a couple of words about the challenges of interpretation at the ICTY. Now, as I said, there's no international justice without interpretation, and interpretation is first and foremost the art of summarizing, of rephrasing. And students are taught at university that meaning comes before words, which makes sense. So that's interpretation. Now, at the tribunal, words are much more important than in any normal conference setting where you have interpretation. And of course, it makes sense, because all the participants, and especially the judges, they have to assess the testimony in its totality. Each and every word is important. It's not just the meaning or what the witness thought he would, what we think the witness said, but basically to render as many words as possible in the other languages. And because also we all know that the credibility of witnesses or anyone it rests not only on testimony does not rest only on credibility, the words, but also on the demeanor, which is very important for the judges, for example, when they're listening to a witness. It is very important for them not only to hear what he is saying, but also to hear how he is saying it. And the interpreters have to convey that to the judges. So unlike normal conference interpretation, the interpreters at the tribunal, they have to convey pauses, they have to convey hesitation, they have to convey the ums and not sure, promptness in answering or not, because that also very often varies whether the witness is being examined in chief or cross-examined. So sometimes they are very eager to respond to all the questions, and in other cases, not so. And that is, of course, very important. So we try to be as accurate as possible, of course, but also to convey everything else that you do not normally convey in a setting with conference interpretation. Also, the interpreters, like everywhere else, get blamed for mistakes that they have made or not. And being a scapegoat is sort of the standard. But at the tribunal, some defendants, especially self-represented accused, were actually representing themselves, so they're given the floor all the time, would often try to disrupt the proceedings by blaming interpretation and saying that the interpretation is not good, that the interpreter did not get the question or the answer. This would even happen sometimes in cases when there was no interpretation, when the question and the answer would be in the same language. And then the self-represented accuser say, I don't think the interpreter got the answer right. Okay. But as I said, we're used to that. And it was actually good that procedure was set up in place for verifying not only interpretation, but also for verifying transcripts, because at the tribunal, we produce everyday transcripts of the hearings. In English, it's a live note transcript, so everything is on the screen simultaneously, and the French transcript is produced an hour after the end of the proceedings. So it's easy actually to go back and compare the audio recording with the transcript and see whether something was misinterpreted or omitted or not. Recently, we had a request by one of the accused, Radovan Karadžić. I assume some of you have heard of him. He was actually challenging the interpretation of his opening and closing statements. So we did an analysis, and it turned out that the accuracy was 98%, which is extremely, extremely high. I'm very proud of it. And it's compared, just to give you an idea, in normal settings, the accuracy goes between 50 to 75%, and that is considered acceptable. So at the tribunal, we really managed to do the impossible. And we have really raised the bar of professional excellence, and I'm pleased to say that other international organizations, not only judicial ones, but others are also following and trying to raise the bar. Now, one last thing, about interpretation and translation is the emotional aspect. Now, when the first trial started, that was back in '95, the war was still going on in the former Yugoslavia. And as you can imagine, the majority of interpreters and translators were from the region or had friends and family living. I mean, I was living in Brussels, but I still had family in the former Yugoslavia. And you can just imagine how difficult it was, and actually still is, for interpreters and translators to interpret and translate, but especially interpret the horrifying accounts of everything that was going on basically in their home country, and to deal with that on a daily basis, year after year. And of course, it did have an impact. And for example, when you have to interpret rape victims, and in the case of Kunarac, where he was charged with rape as a war crime, there were about 20 witnesses, women who had to testify about what they went through. And of course, it's very emotional for everyone, but especially for the interpreters, and who sometimes find themselves, I think you mentioned that once, Kate, in this Dr. Jekyll and Mr. Hyde situation, where you have to interpret for the accused, or the perpetrator, or the lawyer who is, let's say, examining the rape victim in a very clinical manner, putting forward very blunt questions. And you have the witness who not only went through all that, but has to testify about it in open court. And of course, she's trying somehow to, use a different language. But there's no way that you can soften the blow. You can't soften the lawyer's questions. They have to be as they are. So there's no way that you can actually help the victim or witness in go through this horrifying experience. So you're Dr. Jekyll, and then you have to sort of interpret for the victim, and who is testifying broken words very, very emotionally. And often, the interpreters would break down. The good thing about interpretation is that there are always two interpreters in the booth, so if one cannot, deal with the emotional impact, the other usually can and takes over. And also what is interesting is that you assume that the interpreters at the tribunal or any court are the voices of the victims, which we are. But on the other hand, we're also the voices of the accused and the perpetrators. And you just have to be impartial and carry on. Another aspect, which is very specific to the tribunal, is that we had to deal with hate speech. And hate speech, because it goes against the essence of interpretation, which is to communicate, to facilitate communication. Hate speech goes against that. And there was an accused, Vojislav Šešelj, who actually made verbal abuse like one of the pillars of his defense. So first of all, he would be, I would say, shouting while speaking and claiming that that's the way he speaks. So you're constantly exposed to someone being very abusive, not only by what he is saying, but also by shouting, and you have to listen to all that. And so that was also very challenging for the interpreters, and actually difficult because he would also very often be abusive towards the interpreters. So you have the interpreter interpreting for the accused all the abusive things he's saying about you. So that's, but I guess you get used to it, and becoming the voice of the abuser as well. And an additional burden for interpreters is actually the live note, because it can help in some cases, but usually it is quite distracting to have your own words appear on the screen in front of you in the booth. And of course, you can admire your beautiful renderings, but also, you can see the mistakes or omissions that you've made, and all that is being broadcast. And I think the most important part is that actually, the translators and the interpreters, they produce evidence, because what the interpreters interpret in court becomes part of the transcript, and the transcript is part of the evidence, and the judges, of course, quote the transcript throughout their judgments. And yes, as I said, the interpreters have cried during some testimony, but so have the judges and the lawyers, because, oh, is that me? Is this you telling me to stop? Sending me a message saying, okay, let's bring it to an end. As I said, so the judges and lawyers, they're also human. And just listening to all those horrifying stories, and actually because the witnesses are true to life. And last but not least, because the interpreters were echoing the victim's emotions. So that made it more, I would say, difficult in an emotional sense. So I think that translators and interpreters at the tribunal are the true heroes. And I think that they've done an excellent job. And also that they deserve early retirement. And just to end, someone the other day answered the question whether interpreters and translators have bias. And the answer, which now I'm stealing the quote, is, but with that, which I fully agree, is yes, they have bias for justice.
Thank you very much, Maja. Yeah, I think Maja took us there really right to the very centre of the proceedings, to the core of what happens, of course, at the tribunal and what it's there for, which I think was very timely. Thank you. And I think the point you make about the fact that the interpreters are actually creating the evidence, that's how key the interpreters are in our proceedings. As Maja said, the judgments, if you read the judgment, they refer to transcripts, so they're referring to the words that the interpreters often have created in drawing their conclusions. So it's really absolutely at the core of the work of the tribunal in a legal as well as in an emotional sense. So I might take a couple of questions before I move on to our last two speakers. Has anybody got a question for Maja or for, I cut this gentleman off earlier. I don't know if you want to ask it now or save it till later.
Thank you very much, and thank you very much for these very interesting presentations. Storytelling, basically, that's what it is, your experiences over a very long period of time. My question relates very much to the theme of these meetings, legacy. Is it your impression, because after ICTY, of course, other tribunals, criminal tribunals have been created, and the ICC, and you have the experience that everything you have done has been built up almost from scratch, from the beginning, with a lot of camaraderie, pioneering, etc., etc. You have spoken about this. Is it your impression that these other criminal tribunals and the ICC, that they have benefited sufficiently from the experience that you have built up? Or was it more, did you sometimes have the impression of there was a lot of reinventing the wheel, what they have done? Of course, these other tribunals, the ICC, had a different context, but basically they had to do the same job.
Just to say that from the linguistic point of view, luckily the other courts followed the example of our language service. And first of all, one of the reasons is because former tribunal staff actually are heads of all the language services based here in The Hague, just a coincidence, but I guess we were so good that they couldn't choose any other candidates. So, and of course, for them, there was no need to reinvent the wheel. Of course, they adapted to the specific circumstances of their institutions. But basically, I think that all the international institutions, when talking about language and interpretation, they highly benefited from our work and our best practices, and which was actually made their life much, much easier.
Anybody else want to comment?
Maybe I can say, I think that point's actually quite widespread in different areas. That is, a lot of staff from the ICTY have gone to the startup of all these different institutions, so have taken institutional knowledge. And I know in the registry throughout the time of the registry, also before I was there, we spent a lot of time handing over systems and materials. I'm sure you've been involved in that, David. In all sorts of areas, whether it's the legal aid, the defence payment schemes, the court management, I think the e-court for sure that David mentioned. I think some courts have gone a different way, and that's not necessarily a bad thing. One of the obvious different setups has been around the representation of the defence, for example, where you have the Special Tribunal for Lebanon set up, the sort of fourth pillar, the Independent Defence Office, whereas we don't work like that at all. We have worked just with external counsel, and as I said, there is the Association of Defence Counsel, an independent body outside. So there are some different models for that, and perhaps it's good that there are a few different ones are tried out, and we can see what works best. I don't know. In detention, Fraser might come on to that. Or,
in detention, we have kind of a bit more connection with the ICC detention unit, for example, where we're both based in the same building, and therefore we have the opportunity to take advantage of each other's experience and share findings, etc. I think early on in the life of the ICC, particularly, they maybe tried to go their own way in a lot of different aspects, but I think over time we've actually come closer together again in terms of dealing with a lot of the issues.
Okay. Yes, please.
Thank you. My name is Elspeth Cougar. I'm the correspondent of Swiss Public Radio. I've been covering the tribunal for a very long time, and I have a question for Maja. You mentioned Šešelj, the headache case of the ICTY. He was also challenging you not only because of the hate speeches, but also he wasn't satisfied with the language. He wanted, I think he went beyond BCS. How did you deal with that? He wanted some kind of dialect that you would translate it into his dialect. He was complaining very, very many times.
Yes, he was complaining, but it was just, as I mentioned at the beginning, he was using language as a strategic tool to disrupt the proceedings. So, and he was being very abusive about it and insisting that the interpretation should be in pure Serbian, whatever that is. So he was even complaining when there would be an interpreter from Serbia in the booth. He would complain even then. So basically, he was just using it as a tool to disrupt the proceedings and to show his contempt for the institution, for everything. I mean, not only for the interpreters, but it's not a nice thing to have to deal with. But then again, what can you do?
And I think, as Maja said, there was this judicial. the way it was dealt with. Was that there was a judicial decision that, based on this expert testimony, as Maja referred to, that it was possible that the speakers of the different variants could understand each other, and therefore the requirement in the statute that it had to happen in a language the accused understands was met. So I think that was the legal framework which was used to deal with this problem.
So we did not accommodate his or anyone else's needs. When he would say that he would like to have interpretation in the Serbian variant, we did not do that. Of course, we had the interpreters scheduled to work in the booth, whether they were speaking the Bosnian, Croatian, or Serbian variant.
And that was also handled.
Okay, I've seen
Yes,
you
that
want to
was
ask a
also
question.
handled
Can I ask you to save
judicially?
it to
There
the
were
last
decisions.
session? Please do, though. I would love to take your question. I want to move on now to our commanding officer, Fraser Gilmour, who's in charge of the detention unit. Fraser actually also would be on the longest serving. He makes the top 20, having started in April 1998. Is that right, Fraser? Oh, June 1998. David, you've got to deal with these human resources. Give me the wrong data. Yeah. Anyway, so Fraser has been, Fraser might even tell you a little bit about his history, but no, he wasn't planning to. Okay, Fraser's been there all that time, but he's actually been commanding officer, I think, for, not for that long, but he's been acting commanding officer for many periods over the past few years, and he's extremely experienced in the running of the detention unit, and we're very happy to have him. So, Fraser, over to you.
Thank you. Thank you. I'd just like to introduce the detention unit. I'm not sure if everyone's familiar with the setup, and then go on to a couple of the challenges that we've faced. Sounds like challenge has probably been the most used word this evening. I think it's repeated over and over again. So starting with the UNDU, it's a remand institution. It's located within a host prison, the Penitentiary Inrichting Haag, locatie Scheveningen. It's an autonomous managed unit, and it's a function of the registry, as Kate was pointing out earlier. It's regulated under the ICTY's rules of detention, and therefore it's judicially neutral. It's hosting the detainees for both the ICTY and the MICT at the moment.
Explain what the MICT is,
Sorry?
Fraser. The MICT might not be understood.
Yeah, the mechanism for the International Criminal Tribunals, which is the follow-on that I think both David and Kate have mentioned already, in terms of it taking over the remaining residual functions of the ICTY. Functionally, in the role of the detention unit, our mission statement is to monitor and maintain the physical and emotional welfare of all those detained on the authority of the ICTY or MICT in safe and secure detention, bearing in mind the presumption of innocence, defending their dignity as human beings, protecting their rights as individuals, in order that they can understand and participate in the proceedings before them at the tribunal or mechanism. So basically a breakdown of what we do, how we do it, and why, to ensure that all of the detainees can follow the proceedings before them. Important in that is the fact that we're a remand institution, so the presumption of innocence is one of the prime considerations in what we do. The enforcement of any sentences is done in third-party states. Looking at our population, our initial admission was in 1995, which was Duško Tadić, who's been mentioned already this evening a couple of times. And gradually that population expanded, in fact quite rapidly, till we reached our peak population of 64 detainees in April 2005. Since that time, we've had a fairly stable decline in our population, and we're now down to 10 detainees at present. Over that time, since 95, we've had 178 individuals detained at the detention unit. Some of those staying for longer than 11 years and some for only just a couple of days. Works out as an average of approximately 4 years per each of those accused, with an overall total custody time of 708 years of detention that we have had in the unit.
Obviously, we are the only facility for the ICTY, and we hold all types of detainees that there are to support the proceedings. So all those who are accused of war crimes, obviously, are the main number in that group. Also those accused of contempt. Any detained witnesses that we have had at times who've come from, say, from other jurisdictions, and also those who have been convicted by the ICTY and returned from enforcement states as witnesses, and also those awaiting enforcement. So after a sentence is rendered, there's a process to ensure that they move on to an enforcement state. Our detainee profile has been very different from that you would expect in a national jurisdiction. One of the most notable features is the average age of our detainee population. At its lowest, it was 35 years, which is still higher than you would expect an average age to be in a national jurisdiction. Even though in national jurisdictions we're seeing a recent trend of that increasing to higher age, it's still below the ICTY's lowest average age. The reason for the increase apparently is related to historical sex abuse cases, and also the use of DNA evidence in historical cases. So you're getting a lot of older accused arriving in national systems. Today, our average age is 66.7 years. That has an impact on the overall running of the unit. It's been well documented over the years that when we reach about the age of 45 is when we start to experience some of our previous lifestyle choices catching up with us. So in terms of if we've not had a healthy life prior to the age of 45, that's when you're going to start seeing some of the effects of your poor choices earlier in life. This means that we have high instances of cardiovascular issues, a lot of metabolic problems, and also skeletal issues, in particular, amongst other issues. Earlier on in the life of the tribunal, we also had a lot of cases where there were wartime injuries, where particularly when we had a number of the accused very early in life were charged more with the perpetration of the crimes rather than with command responsibility. So a number of those had arrived with particular wounds experienced during the conflict. To give some context, we hit the average age of 45 in 2001. Now our detainees are all in the age range between the late 50s to their mid 70s. And this creates a number of new concerns in terms of managing issues with an elderly population and health problems that are experienced generally later in life. Generally, all of our detainees now come from a position and educational level, which is high-ranking public officials. They come from a very high educational level, which is a complete contradiction of what you would normally find in a national system, where generally your staff would be better educated than the average detainee. We have the reverse of that situation, where generally our detained population are better educated than our staff. Also, that creates different levels of expectation. We've seen a very different change in the way that the detainee population handles themselves and the way that they expect different things from the system. And that's added some difficulties for us at times. They're not habitual criminals in general. Even those that were charged with the perpetration of the crimes earlier on in their life, they've not generally gone through the university of crime, as it's referred to, with in and out of jails and young offender institutions, etc., through their early life. It's the first time that most of them have been deprived of their freedom. They're also very much distant from their support networks. Generally, all of our support networks are formed by our family and friends. We've dragged this group of individuals over to the other side of Europe. And again, as we get older, our coping mechanisms reduce, making it more difficult for us to deal with change. This creates a number of psychological stresses and impacts. And as an institution, we are a single institution, and we have to cope with any of the challenges that have been thrown at us from a detention perspective. Many of those are similar to what you would find in a national prison system. However, we've had to achieve it as a single institution with a limited infrastructure. So moving on to some of the areas that have been particularly challenging and related to the healthcare in particular, because that's been a main theme of the work that we've done in the detention unit over the years. And the fact is that the significance of the duty of care and the provision of healthcare is not something which can be minimised or lost when it's taken into the judicial environment. Often the issues are related to the separate requirements of the law and medical ethics. A couple of instances where the two have been irrevocably thrown together is in the management of hunger strikes and the use of medical material in the judicial proceedings. In relation to the hunger strikes, they're very often a very emotive subject, which can cause a great deal of disruption and distress to everyone involved in the management of the detention facility, and also in relation to the treatment of the individual. Many question why a detainee should be allowed to hold an authoritative body to ransom in what can be seen as an attempted suicide. The striker supporters will question why the authoritative body cannot see the error of their ways and blame them for allowing the striker no alternative. Those managing the strike are the ones left somewhere in the middle there. At the end of 2006, when Mr. Šešelj decided to go on a hunger strike in the detention unit, we were faced with a similar situation. It was the first occasion on which the UNDU had been faced with a particularly motivated and experienced hunger striker, and there had been many other less experienced and less motivated hunger strikes occur, some even where the striker had gained weight after the alleged strike. To give some context of when this occurred, the Šešelj hunger strike occurred in the same year that Milošević and Babić had died in detention. There was an enormous amount of public scrutiny on the UNDU and its operations, and particularly its provision of medical care. It was a total hunger strike, and it was successfully treated and managed through the experience gleaned from many different parties. Notably taking advantage of the experience from the host state, prison service in managing hunger strikes, and also guidance from the World Medical Association's Declaration of Malta on hunger strikers. Also noting that the World Medical Association had updated and issued a more nuanced version of the declaration, which gave a lot more depth to the way that a hunger strike should be managed. World Medical Association, I maybe should mention, is an international body which deals with a lot of the medical ethics that are involved in world health. Isn't attributable to any country or answerable to any country, and therefore it's able to deal with entirely the issues of medical ethics without being concerned with some of the areas of the law. What became clear upon conclusion was that we needed to put these procedures in a more suitable format for an international environment. A protocol was needed that would explain to all parties the legal, medical, ethical and operational considerations relevant to their roles. We all bring our cultural, historical and political experiences with us when we come to a new role, and I think in terms of making those
different perspectives work in an international environment is often can be coloured by our training and backgrounds, and therefore it's important that we have something that met with all of the international expectations. At the time of this hunger strike, we were under a lot of pressure to force feed Šešelj should he ever fall into well, not coma, into incompetence, I would say, incapable of making further decisions for himself. And was explained that it was never acceptable under medical ethics to force feed an individual, with the difference between artificial feeding and force feeding explained. However, there were still further demands and expectations that we would bring in doctors and medical staff who would be willing to perform this task. It seemed that at the time that all parties had some kind of suggestion on how to manage the situation. So inevitably it was important that we had a protocol that could be used across the board. So assessing what was particularly required, there were some key steps. Firstly, understanding the definition of a hunger strike, or more accurately what we refer to now as a voluntary protest fast. And a voluntary protest fast is exactly what it says. It's voluntary, there's no external coercion. It's a protest at some perceived wrong, and it's a fast which involves the limitation of food intake. Anything which doesn't tick all three of these boxes, therefore, is not a VPF, or a voluntary protest fast, and must be handled under very different criteria. For example, a person who is suicidal will not be treated medically, and not as a hunger striker. Secondly, understanding the four main types of voluntary protest fast and the differences in handling them. There's a dry strike, which means refusing all food and drink. This has a very short time scale. Death can occur within 1 to 2 weeks. Therefore, it requires extreme acute handling. Then there's a total strike, refusing all food but continuing to take water. Death generally occurs in approximately 8 to 11 weeks, and therefore you have your time scale in which to deal with it. A non-total strike would be refusing elements of nutrition, and the means of dealing with this can vary dependent on which elements of nutrition are being refused. And then there's a food refusal, which is refusing the food provided by the authorities, which is rarely life-threatening. Thirdly, there's understanding the impact of other medical conditions on the course of a voluntary protest fast. For example, someone with particular health issues may cause, when you stop taking food and drink, etc., then you can reduce your ability to fight off your normal problems. And also understanding the ethical dilemmas of the medical profession. The UNDU management and the medical staff pulled together much of the medical and operational information in preparing the protocol. It was the legal staff in registry who coordinated the preparation of all of the legal information, with all of us coming together in relation to the medical ethics and combining all of the information compiled. Outside assistance was sought from the host state prison service, the host state prison hospital staff, and also the Johannes Veer Stichting, which is a Dutch human rights organization for medical professions, and also the International Committee for the Red Cross. One of the successes of the approach in the management of the Šešelj hunger strike was communication, and this became one of the binding factors in drafting the protocol. It was important to sell the protocol in an international context. Regular briefings between all parties continued throughout the drafting process and culminated in an excellent roundtable briefing for all interested parties, legal, medical, operational, and included chamber staff and judges, to which the ICRC sent legal advisors and their voluntary protest fast guru, Dr. Hernan Reyes. We now have a protocol which has been highly effective in managing VPFs. Detainees are advised at the commencement of a voluntary protest fast
You should be aware that under the guidance of the Declaration of Malta and in acknowledgement of your right to use your body in protest, should you be determined to take your protest to its ultimate end, you will be allowed to die with dignity rather than resuscitated against your will. This advice on its own has, on more than one occasion, been considered enough to persuade a detainee that there may be alternate means to protest. One of the successes of the consultation process was the acceptance of the World Medical Association as an authoritative body with international standing, which can provide provide guidance to other international bodies on medical ethics issues, as opposed to the national bodies, which were all bound by their own laws. And I think I'll end there.
Thank you very much, Fraser. I'm keeping an eye on the time, which I realise is, I think we... As I said, I think we did start 15 minutes late, which is unfortunately going to cut into the last two speakers. But thank you very much, Fraser. I'm sure there'll be lots of questions for you, and I'll try and see if we can fit some in. Fraser has a lot more to say. But I think that process of drawing up the voluntary protest fast protocol was a really interesting example to you of how different aspects of the registry collaborated over a really critical issue. I'm going to turn now to Ljiljana Hellman. Last but certainly not least, although when we came in, Lily told me she had a 10-second presentation, so this might work out actually okay, but I'm afraid that means she's going to talk very fast. Lily has done a whole range of, there we are, trying to find out when you joined the tribunal. So Lily joined in 2010. Lily's a lawyer in the registry. She's worked in a range of positions, but tonight she's going to speak briefly to us about her role as the pro se officer, and she will explain to us what that is. Lily, thank you very much.
Thank you, Kate, and thank you all. I'll take you a little bit back to history travel. My colleagues mentioned the Milošević case, and I don't know if all of you are familiar who the Milošević was. He was a war crime president of Serbia and one of the main faces of the wars and events during the conflicts in former Yugoslavia. And today is actually anniversary. On the 5th October 2000, he lost the power. He admits that after a big riots in the country, he admits that he actually lost the elections and that he is going to retire. However, at that time already existed indictment by ICTY against him, so his retirement turned, how many months? It was in June. In 28th of June, he was actually surrendered to tribunal by the new government then. And then the saga about process starts. Milošević didn't recognize the tribunal, so that was his kind of attitude, showing that he doesn't recognize this institution, he doesn't recognize the court, and he was really unwilling to cooperate. And it was difficult to bring him into the game, bring him into the procedures. And since the very beginning, he didn't want to have any counsel assigned to defend himself. He, being a lawyer himself, he wanted to present himself, even still repeating that he doesn't recognize the tribunal. So since the first status conference in August 2000, the chamber did recognize that he indeed has the right to represent himself based on our statute, Article 21, which didn't explicitly say that this right exists as such, but it did say that it doesn't exist. He has a right for a counsel on his choice. If the counsel of his choice is he himself, then he can make this choice. On the other hand, this was the way somehow he was accepting the game little by little by being able to represent himself. He actually started to engage in proceedings, which was a good thing because the proceeding can start rolling on. The difficulty was that the other part of the same article requires that he is given enough time and sufficient facilities to prepare his defense, to prepare his case. And the challenge was then turned to the registry, and the chamber asked the registry to find the way how to assist him to present himself, although being in a detention unit. So the registry started exploring, is there anything in other jurisdictions, in other national jurisdictions? Yes, there are examples, but very rarely or almost none in criminal cases. Okay, so we looked what there was. There were different offices, process clinics, self-help offices in different national systems that were providing some kind of assistance to those who, mostly in civil cases, decided to represent themselves. So step by step, trying to collect all this information, we didn't invent the wheel, so we combined the experience of different countries and put them together in one process legal liaison office within the registry, which was tasked to provide first Milosevic and then the others who decided to defend themselves as well, like Šešelj, like Karadžić, to assist them in defending themselves. From the beginning, so this role for a legal officer assigned was really, really difficult because it was always dense on a very thin line between trying to provide them with assistance they need, to provide them with information, what tools they have, with information, what legal possibilities they have, because it's difficult even for lawyers to understand completely new institution. It's not a national institution when you as a lawyer or even a citizen, you know what to expect, you know what the rules are, you know how the courts in your country function. This is international court and it's completely new for everyone and especially challenging for a self-represented accused who is detained. So giving all these tools and explaining what options someone has, but without giving any legal advice, without giving any interpretation what these rules are telling him, without suggesting or advising anything, which was difficult. On the other hand, a lot of us being in this role were speaking their language. So it was always really amazing how having contact with self-represented accused, so we talk the same language, and at some point when I would start explaining to them what options they have, what rules they can use and should consult or to deal with, then they start asking questions because we speak the same language. Suddenly they feel like, okay, she's on my side, she's trying to help me. So what do you think? What, shall I use this or that? Then I need to step back and use very official language, very cold. No, I am not allowed to give you any advice as a registry representative, blah, blah, blah. Then you can see this total switch that they see you as if you're like masked Paul. Okay, no, she's an enemy. She works for evil court. So it was always difficult to explain that we are neither one or another. So to explain the exact role of the registry. So this whole role that we are explaining, that the registry in the International Tribunal is something that doesn't exist in national tribunals, and which is difficult even for lawyers to explain how it functions and how complex it is. Here, it was in a really mini case between you and the self-represented accused when you need to explain this all complicated saga, what your neutral and middle role is. And the tasks that we were faced were so different. Sometimes it would be, first, the experience with dealing with self-represented accused was different. Some were trying to just get a minimum assistance. Some were using a lot of assistance from our side. Some of them, because they were choosing to be their own lawyers, they took part of somehow a lead counsel. Each lead counsel of represented accused would have possibility to have entire team, funded team of co-counsel, researchers, legal assistants. So self-represented accused had the same ability. They could hire their legal consultants. So some of them choose to have a minimal support and to use this support really rarely, while some had really developed huge teams so that they were equipped also almost as if they were represented, only just they were the ones talking in the courtroom. So the level of support and interaction we used to have with them was really different. For example, one of self-represented accused was so frequently in contact with 3 pro se legal liaison officers as we switched in our roles, that he kept for years through his legal associates or all registry staff who would get in contact with him to send warmest regards to all 3 of us all the time. And when it comes to the tasks that we were dealing with, it could be really complicated legal questions, how we will approach to assist someone in a particular situation, to provide this person with particular tools without crossing the line of our neutrality. So it could be drafting very careful language, trying to find a very careful approach, consulting, making a research of comparative analysis of different legal systems. And on the other hand, it can be totally different, very banal story. Like, for example, my colleague who worked before me as a pro se legal liaison officer with Milošević case, she was faced with a situation when she was sometimes sitting in a court so that, because legal liaison officer is the main channel of communication for a self-represented accused and all other organs of the registry and organs in the court. Because they don't have, as lawyers, a means of direct communication, they need to have someone to assist them in communicating. So in courtroom, it sometimes was needed as well. So while Milošević was talking, he had a clicking pen in his hand, which was near to the microphone. So interpreters had a problem with interpreting. They didn't hear him. And what he was doing, this clicking pen, he was probably doing it automatically, being not aware that he's doing that. And then interpreters were complaining, so the judges asked the pro se officer to try to tell him not to do that. So she was doing what I'm going to do. So even if I tell him, he will forget after 5 minutes. So she took a little box with stationery and find a pen that didn't have any possibility to make a clicking sound. So she went to him and offered him to switch the pen with him and explain what's the reason. So he was a bit confused. So he took the pen, she took the clicking pen, so it continued normally. So that was like one of the challenges, which is totally different. And
I think, Lily, I feel justified in going till maybe 7:15 because we started 50 minutes later, and we have got a reception for you afterwards. But it's 10 past now, so maybe I could ask you to just wrap up really quickly, so we have time for just a couple of questions, and maybe they would be.
I think that I will leave it to you to ask questions. This was the gist of the pro se role, and yeah, if you have any other questions for me or my colleagues, that would be it.
Fantastic. Thank you very much, Lily. So from the clicking biro to the legal advice or the non-legal advice. Okay, well, I hope that we've given you some idea of the range of registry activities. All of these people could talk about their work a lot more. I said we've got, well, let's say 5 or 4 more minutes. So maybe we could just take a couple of questions and then we can move into the reception. I think there was a question here. Is it still want to pose itself?
Yeah. Thank you. My question is for Maja. Basically, I think language or this translation is the backbone of the trial system and everything. I know that this is, from my experience, is very difficult when the judge sitting there normally take questions or understand the person, a witness or an accused who speaks a different language. I actually even read once, there were words which were very difficult to translate it in English. I'm talking about the ICTY case. That's from Kenya, Rwanda to English or French. So to what extent that was the case here in the ICTY, and how much it affected the quality of the case, especially in rendering, in finding the truth. And probably in the future, we may think of some ad hoc tribunals like the ICTY, for example, in case of Syria. They may establish a new ad hoc tribunal. Do you think, from your experience, that the judge should be someone or judge who can speak the language of the accused and the witnesses? Because normally details will be lost in translation. It affects really the quality of the judgment.
Just see if there are any other questions, just in the interest of time, and then maybe we can answer them. Yeah, just take maybe one or two more questions, please.
My question's for Fraser. You touched upon the cultural issues of an individual moving to The Hague while detained, and also the shock of being in prison for the first time, because they're not necessarily career criminals. How did you deal with that, and what were the main challenges?
Thank you very much. Last question, anybody? Okay, in that case, please.
Well, at the tribunal, especially at the very beginning, we had a difficult task of actually creating new terminology, because the system, as you know, at the tribunal was actually a hybrid legal system, and it combined the common law and continental, which was the system used in the former Yugoslavia. So it was actually a very demanding professional task, finding legal equivalents. That was the main task. Of course, sometimes words had to be invented or something had to be rephrased. And those new, let's say, new words have become standard practice. And that is also what our colleagues at the ICTR did. Because in Kenya, Rwanda, you did not have equivalents for all the legal terms. So they had to expand, basically, and in some cases even to explain certain terms. And in other cases, when you're talking about normal terminology, you know, like military or whatever, there were words that were difficult to translate either into English or into French from BCS. And the most important thing was not actually how that word would be translated, but to convey the exact meaning of the word. Because, of course, the defense would challenge certain interpretation or translation terms. And, for example, at the tribunal, we had a lot of discussion about the term in BCS, it's asanatia, which was translated as mopping up the terrain after some military activity. And the defense was, of course, opposing, because mopping up, does that include bodies? That does not include dead bodies, and so on. So at the end, in that case, the judges, they defined what the word meant, and everyone agreed to the definition of the word, and they actually used the BCS word asanatia, or it became an English word, asanation. Jeffrey Nice invented the word, and he used it throughout the trial, and everyone knew what he was talking about. And if you read the transcript, you will see that there's an explanation what asanatia is, and then you'll see asanation throughout the transcript. And to answer your last point, I think that if the interpretation is and translation is as good as it is at the ICTY, I don't think that there's any challenge or that much is lost in translation, which was a good movie.
So moving on to your two questions. two different aspects. You're talking about sort of staff perceptions and the detainee perceptions. In terms of dealing with the detainees on their arrival in a different cultural environment, we do try and allow as much contact as we possibly can with their loved ones, we permit a huge amount of visiting, contact through telephones, mail. We're looking at other options in terms of digital communication recently. And therefore that's a way of minimising some of the issues with arriving within a different culture. Having said that though, of course, when the detainees arrive, they're into effectively a small community within the detention unit of similar people from similar backgrounds, both culturally and even if they may be on different sides of the conflict, generally they've had longer as Yugoslavs than they have in conflict, and therefore there's a lot more commonalities there. In terms of arriving with our own preconceived positions, as is inevitable for any people, I think it's really in terms of when we get new staff on board, etc., we always try and explain the culture within the detention unit, the culture that we try to express, and that's the way of ensuring that everyone is on the same page. That answers your question.
Thank you very much. Then it just remains to me to thank you. I'd also like to thank the donors, actually, who've made this lecture series and all of our legacy events possible. That's Finland, Germany, Malta, Switzerland, our host country, the Netherlands, and the European Union. And to let you know that the next in this series will be looking at the ICTY from the defence perspective, and that takes place, I believe, in 2 weeks' time here at the university. Thank you all very much. And thank you again to our panellists.